Okay, the the video recording has started. Okay, this is the meeting of the Sunshine Ordinance Task Force Complaint Committee for October the 18th, 2022. The time is 5:34 p.m. Just give you a few announcements before we get started into roll call. Members of the public may participate by phone or may submit their comments by email to sotf@sfgov.org. All comments received will be part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sf.org/sunshine. As the COVID-19 disease progresses, please visit the task force website to be updated on the current situation as it affects the process. Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of the meeting participants. Person who engaged in threatening and or menacing behavior may be asked to leave. The first item on our agenda today is call to order, roll call, and agenda changes. On the call of the roll, Member Stein.
Here.
Present. Member Wolf. Wolf is present, but let me unmute him again. Member Wolf?
Yes, can you hear me now?
Yes, I can.
Yes, present.
And Pierce Smith.
Present.
Smith present. We have a quorum. Give me one moment. I just want to document this before. Okay, I do have one requested change. For item number 4, Mr. Manette Shaw has requested a continuance of his item due to a personal issue. I do have one person with their hand raised. I don't know if that's Mr. Manette Shaw or not. I'll go ahead and unmute them at this time. Hello, caller. I've just unmuted you. Can you?
Can I what?
Okay, one moment, please. I'm just wondering why you raised your hand already. Please wait until we, and then I will call on you again later.
I wanted to make a comment about item 1 for an agenda change.
Yet, please. I have not asked for comment yet. Okay, we have a request from Mr. Manette Shaw to continue his item to the call of the chair due to personal circumstances. I leave the discussion to the chair.
I did see a message about that, and I'm inclined to continue that matter. Members, do you have any other thoughts? I understand there's a personal issue of Mr. Manette Shaw, and so we would just move it to a later date.
Yeah, I mean, I'm also inclined to give a continuance if that's what a petitioner is asking for. The one thing I want to throw in there is it seems like this happens not infrequently. And I'm just wondering, like, if we know a few days in advance, I would love to have that passed on somehow. Just because for this particular case, I think I spent just hours and hours and hours researching HIPAA and CMIA and really trying to untangle the privacy issues. And I mean, I'll have that there for the next time that we handle this, but I could have held off on that because this was a rather long packet.
Yeah, I know he's dealing with some very serious personal issues right now. But I was under the impression that he had asked for the continuance some time ago.
This is Victor. Originally he was hoping to be able to attend today's meeting, but his condition just took a turn, and only a day or two ago he requested the continuance.
Okay. Yeah, I'm inclined to accept it anyway, but just mentioning this for future.
Sure. I'm sorry that you went to that level, but I appreciate you doing that. Let's make sure that when this does come up, we don't waste your effort having done that homework on the case. Yeah, so I will be glad to move that to later, so we'll not hear number 4 today.
Okay. Okay, can we take that as a motion and just take care of this at this time? Chair Smith, is there a second to continue the call of the chair?
I'll second it.
Okay, that is Chair Smith, seconded by Member Wolf, to continue this matter to the call of the chair. If we can go ahead and open this up to public comment. If you would like to raise your hand by pressing *3 or otherwise using the application to raise a hand, I will recognize you for public comment. We have, I believe, Mr. Warfield on the line. I will unmute his line at this time. Mr. Warfield, you may proceed with your public comment.
Is this public comment on only the motion or on the agenda item?
This is on the motion to continue.
I have no problem with what the body is recommending. That's fine, but I do have a comment on the item itself. Thank you.
Okay, I don't have any additional hands raised, but I believe we're only taking comment on the motion and not on the item itself today, as we are continuing to a future date. I will defer to Chair Smith on that issue.
Yes.
Okay, I do not have any additional public comment on this item. So I will go back to item 1. I only noted that one agenda change. Is the committee aware of any other agenda changes?
Victor, I think we should have a vote on that.
Oh, my apologies.
That's all right.
I made the assumption.
No problem.
On that item 4, to continue to call of the chair, on that motion, Chair Schmidt.
Aye.
Schmidt, aye. Member Wolf.
Aye.
Wolf, aye. Member Stein.
Aye.
Stein, aye. The motion passes without objection. And going back to item 1, is there any additional comments regarding roll call and agenda changes?
Nothing else.
Okay, I do have a request for public comment from Mr. Warfield. I will go ahead and unmute him at this time. Okay, Mr. Warfield, you may proceed.
This is Peter Warfield, Executive Director of Library Users Association. Library Users 2004 at yahoo.com and P.O. Box 170544, San Francisco, California 94117-0544. The item references agenda changes. I don't know if this is an agenda change, but let's say that item 6, which is our complaint about the library Prop G calendars, is missing one of the 2 sections that we specifically took efforts to have included as we had it in the original complaint. So the description, we were also told the description is the same as the agenda item. So the description mentions 2 sections of the Sunshine Ordinance, 67.25 and 67.29-5. That's immediate disclosure request violation and Prop G calendar violation. But the agenda item only mentions
I'm going to go ahead
one.
and pause the timer momentarily and defer to Chair Smith. This seems to be discussion of the item itself.
The agenda item is incomplete. That's the point. As written.
I defer to the chair. I have muted Mr. Warfield temporarily, so we can give Mr. Chair Smith a moment to speak.
Yeah, thank you, Victor. I'll allow some latitude.
Okay, I will unmute Mr. Warfield and continue his timer. Okay, Mr. Warfield, you may continue.
I'm not talking about the substance. I am talking about the agenda item as it's on the agenda. And the agenda item, as it's on the agenda, is missing one of the two citations of law that were in the complaint and that are actually in the complaint summary, which got there because of some efforts on our part and a correction on the part of Ms. Legere. So I don't know how you want to proceed, but I would want the complaint to go forward on the basis of both elements of the complaint, basically as you see it in the complaint summary at this time, but it didn't seem like it got into the agenda, the current agenda that's before us. So I'm not sure how you want to handle that, or if you would like any more information, I'll be glad to answer any questions.
Okay, thank you.
Okay, we have one additional caller requesting public comment. I'll unmute them at this time. Hello, caller. You may proceed with your public comment.
Thank you very much. This is anonymous number 3. I wanted to support the specific part of Mr. Warfield's comments that agendas should cite complaints as stated by the complainant. The complainant chooses the allegations and the complainant chooses the respondents. And I know when I have asked for similar corrections, at least the full task force has made those corrections during this phase of the public meeting. Thank you very much.
Okay, I'll go ahead and make a last call for public commenters. You can press *3 to raise your hand or otherwise raise your hand. Seeing none, I believe we can close public comment on this matter. Give me one moment. Trying to get my phone to stop timing. Okay. I believe that completes public comment on item number 1. Would you like to move to the next item?
Yeah, and I think if there are issues around the agenda and number 22107, maybe we can talk about that when that matter comes up. But let's go on to number 2 for now.
Okay. Item number 2, approval of the September 20th, 2022 Complaint Committee meeting minutes.
Any revisions from the members? I do not have any.
Yeah, I didn't see anything. I'd be willing to make a motion to approve the minutes.
Okay. Is there a second to that motion?
I'll second.
Okay, we have a motion moved by Member Stein, seconded by Chair Smith to approve the minutes. I'd like to open this matter up to public comment at this time. If you'd like to make any comments on the approval 3 at this time, or otherwise use the application to raise your hand. I'll just give people a few moments to raise their hand if they would like to. Okay, I do not see any indications of anyone wanting to speak on this matter. So moving on to the vote. Give me one moment. On that motion, Member Stein.
Aye.
Stein, aye. Chair Schmidt.
Aye.
Schmidt, aye. Member Wolf.
Aye.
Wolf, aye. The motion passes without objection. Item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction but not on today's agenda. If you'd like to make public comment today, you can go ahead and raise your hand by pressing *3, or otherwise using the application to raise your hand. I will go ahead and unmute your line. Okay, we have one caller so far. I will go ahead and unmute their line. Hello, Anonymous. You may begin your public comment.
Thank you very much. This is anonymous number 3. I'm going to talk about 2 issues. One, there was some concern at a prior full task force meeting, I believe, about whether members can recuse themselves from a vote without getting a majority approval by the rest of the task force. And your bylaws actually say they can. I think one of the issues was Member Schmidt recused himself in a complaint against the task force itself, stating certain rules about attorney conduct, and someone wondered, actually, is he allowed to do that? And as far as I can tell, the bylaws do say anyone can recuse themselves for a conflict of interest, or if a majority of the task force say they must be recused. Second, as always, I talk about victories using the Sunshine Ordinance. As was widely reported, the SF Standard discovered these undated resignation letters from various mayoral appointees. And then Supervisor Preston held a hearing about this. And the mayor's office has lied either during that hearing or in the requests for these resignation letters in communications I have found to another source. And this kind of comparison where you can compare a politician's words on tape versus what they put in an email is one of the beauties of the Sunshine Ordinance and why it must be enforced strictly and precisely. Thank you very much.
Thank you. Okay, if there anybody else who would like to make public comment at this time, you can go ahead and press *3 to raise your hand. I'll give everyone a few moments. Okay, seeing no additional hands raised, I believe we can go ahead and move on to our first our next item. So our next item is item number 4. Actually, item number 4 has been continued to the call of chair as earlier on the agenda. We'll move on to item number 5, which is file number 20104, complaint filed by Anonymous against Dennis Herrera and the City Attorney's Office for allegedly violating Administrative Code, Section 67.21D, by failing to issue an order to comply with a records request when acting as the supervisors of records.
Okay, before I just give a brief recount of how we're going to do the process here, I just want to acknowledge the reference to what I'll say is the importance of the presence of the Sunshine Task Force and the fact that the departments of the city are aware that it's there, and they're aware that there is a process that can happen here. Okay, for each of the case hearings, we are going to start with a statement of up to 3 minutes from the petitioner, and then the respondent will have a turn. A representative of the respondent will have a turn of also up to 3 minutes. After that, the members may have questions for the parties, and then the members will deliberate, seek to possibly move the matter forward to the full task force. There are certain aspects of a case that we're focusing on here. We want to see if the matter really does deal with public records or public meetings. If the task force actually does have jurisdiction over the matter, we may have certain recommendations for the task force, and as is commonly done, we may move the matter forward to be heard in a separate hearing by the full task force. With that in mind, when the timer is ready, we are ready to hear from the first petitioner.
Okay, and just to clarify, how much time would you like to allow in this initial stage?
This will be up to 3 minutes.
3 minutes, okay. And I just wanted to bring to the chair's attention and possibly both parties, this issue has come up earlier today regarding Mr. Herrera. since he is no longer with the Office of the City Attorney, who should this complaint be officially list Mr. Herrera as an individual and or specific departments? I just want to bring that to everyone's attention if we can address that eventually. Okay, first up would be Anonymous. You will have 3 minutes. Your line is unmuted. You can proceed at your own discretion.
Thank you very much. This is Anonymous, the complainant. I'm not completely sure what Mr. Young is talking about. I originally named Dennis Herrera in the City Attorney's Office, and I then dropped the City Attorney's Office because I was incorrect. The law does not obligate the City Attorney's Office to do anything. It obligates the, quote, the City Attorney to do something. And as I've discussed in the various other cases against the City Attorney, at the time Dennis Herrera, that's the person Dennis Herrera, or at that time was. Anyway, now to the meat of the case. This is a very simple question. Once the supervisor of records, who at the time was Dennis Herrera, determines in a response to a petition under Admin Code 67.21d that certain information is public, is he actually obligated to do what the law says and immediately issue an order to comply with the records request? And they argue, of course, that you don't have any jurisdiction, but that's never what you have held before in supervisor of records cases. Sometimes you have found that the city attorney violated the law, and sometimes you have found that the city attorney did not violate the law, but you didn't find that you didn't have jurisdiction over the issue. And the reason for that is you, the Sunshine Ordinance Task Force, have the authority to conclude whether any person has violated the Sunshine Ordinance, Brown Act, or Public Records Act. And I'm asking you here to determine whether Dennis Herrera, when acting as the supervisor of records, violated Admin Code 67.21d. And even if you disagree with me, even if you think I am wrong, then that is the full task force's decision to make and not Justice Committee's. And I invite you, if you think I'm wrong and you believe that the supervisor of records does not have to actually comply with what the law says, I want you to rule against me. Because once you make the ruling that the supervisor of records does not have to comply because of their various arguments, chief of which is that the city charter basically would prevent them as the city attorney to order their client to do anything, which I guess is the gist of their argument, then it's time to change the supervisor of records law, because it doesn't actually, the public isn't actually getting the benefit of the supervisor of records law. And you might wonder, in all the dozens of petitions, which generally every time I file a complaint with SOTF, I also file a petition with the supervisor of records, how come this is the one I chose to file this kind of complaint about? And that's because in hundreds of petitions for both me and everyone else who has filed a petition since approximately 2015, this was the first time that Dennis Herrera, as a supervisor of records, gave a written determination that the petitioner was in fact in part correct. And that's the only part I'm complaining about here. The supervisor of records, rejected 2 parts of my complaint, but he said that he agrees with me that the information about who made those records requests is, quote, not private, thus public. And my argument is, once he came into that conclusion, gave me that written determination that that information was public, that the law says he must order.
Thank you. 3 minutes for the petitioner has elapsed. Would you like to move on to the respondent this time, Chair Schmidt? Your microphone is muted, Chair Schmidt.
Sorry about that. Thank you, Victor. If he could just wrap it up, I'll give him a few seconds. Do you have anything further, Anonymous?
Yeah, I'll just finish my sentence. That once he determined, he gave me the written response that the information was public, the law clearly says he must immediately order the custodian to disclose the record. That's it. And he didn't.
Okay. And now if we have somebody here on behalf of Dennis Herrera, when the timer is ready to start.
I believe that we have Jen Court with us today. If you can go ahead and identify yourself, it would be appreciated.
Yes, can you hear me?
Yes, we can.
Okay. Can I go ahead?
Yes, please proceed. Sorry.
Okay, that's okay. Thank you. Hi. Good evening, chair and members. Jen Court with the City Attorney's Office. There have been a few complaints in recent months that have been before this committee, in particular dealing with the city attorney's role as the supervisor of records. And I think for the most part, you're generally familiar with our arguments and general arguments in each of those. So I'll try to be brief. The first chiefly is that the Sunshine Ordinance clearly lays out two separate processes for recourse for members of the public seeking public records, one through the task force and two through the supervisor of records. Those processes are separate and do not have an impact on one another. Section 6721E clearly describes the jurisdiction of the task force in situations where the supervisor of records does not act or the petitioner disagrees with the supervisor of records course of action. They can file a complaint with the task force, and the task force can issue a ruling or a violation against the custodian or the department from which the petitioner is seeking records. Language doesn't authorize the task force to find the actual supervisor of records in violation of the ordinance. Second argument is the city attorney has to perform its duties as the supervisor of records in a way that's consistent with the city charter, specifically our duty to provide advice to departments and elected officials. A finding of 6721D would conflict with the city's charter and the St. Croix decision, which held that the Sunshine Ordinance cannot supersede or negate the city attorney's obligations to provide advice or counsel. The petitioner is arguing that a finding a violation of the ordinance is not the same thing as ordering the city attorney to do something. We believe there's no difference between finding a violation and ordering us to take a specific action. Finding a violation of 6721D would amount to the task force telling the city attorney how to advise its clients and would interfere with our obligations under the charter to provide advice. In this case, we publicly advised, as the petitioner notes, SFPD, that some of the information the petitioner was seeking should be produced. We did not order SFPD to act because doing so would be inconsistent with our advice duties under the charter. For these reasons, we respectfully ask the task force not find jurisdiction and dismiss the complaint, and happy to take any questions. Thanks for your time.
Okay, thank you. Members, it's time for any questions that you may have.
This is Member Stein. I do have some questions. I'm having trouble understanding why advising and also ordering are necessarily in conflict. Because you can advise people, and in a narrow instance, you can also tell them that this is something that they should do. So I'm just wondering, can you explain how asking them to do it abrogates an attorney-client relationship? Particularly when there's like no legal case there. This is one of the arguments that you made. I just want to make sure I fully understand this argument.
Yeah, I mean, I also see where your question is coming from. I think the difference is kind of what you said, saying that someone should do something. From our perspective, that's what we did. We did say, we publicly advised that they should make these records public. It's a little bit different to order someone to do something or order one of our clients to do something. Our role as counsel is to provide advice, and we can provide varying degrees of advice, right, from a very light touch to saying this is what should happen, but ultimately it's our role to provide advice. What our clients do with the advice, that is truly up to them.
Okay, and when you say you publicly provided it, did you provide it directly to them, or was there just this statement that you made in the context of this case, which they may or may not have seen?
We provided it directly to them as well as in writing to the petitioner.
Okay, and then it seems like when I read your arguments, like you're arguing that you cannot follow Sunshine Ordinance 67.21D because it conflicts with the city charter, and therefore conflicts with the mandate under the Sunshine Ordinance to order public records custodians to provide public records. And I'm not sure, given that the Sunshine Ordinance also says that it supersedes other local laws, why you wouldn't follow that line of legal reasoning.
So I think that really ultimately comes down to the court case, the St. Croix decision, which the Court of Appeal found that the Sunshine Ordinance cannot supersede our duty as counsel to provide advice under the charter.
But this doesn't stop you from providing advice. It just asks that you occasionally make an order.
That's right. And I think that the difference here is just that we see a pretty clear distinction between providing advice, even providing strongly worded advice, versus ordering a department to do something.
Okay, I'm also wondering, this is not quite related, this is a slightly different question for the respondent, but you say in the letter that you reviewed the records to determine whether or not they were properly redacted. Can you tell me by what process you reviewed the records?
I believe a deputy on our government team went through the records and worked with SFPD to understand the redactions.
Okay, those were my questions.
Thank you.
Okay. Member Wolf, do you have any questions?
Yeah, I have one question for the respondent. Just following up on the last line of questioning that Member Stein had put forward. I mean, if you're saying that you can't fulfill the duties as supervisor of records to order your quote unquote clients to comply, then would you then agree that the city attorney is unable to fulfill the role as supervisor of records completely?
I don't think that we would necessarily fully agree with that, just because I think I've explained in a previous meeting, our approach to this supervisor of records function is usually to work with the departments to get them to produce any records that may be public. And in a vast majority of instances, they do produce them. So I don't think that the function is totally null and void or totally useless. I think maybe what you're asking.
Well, I think, I don't know. It feels like if you're trying to help them to comply, then the obvious thing is that you're helping them to comply with the law. So whether you are instructing them to do it or counseling them to do it or whatever function you're performing as the supervisor of records, you have to kind of determine which one are you. Are you this bifurcated role? So in one role, you are the supervisor of records and have a duty under the law to perform a function, or are you the city attorney in representing their client? So you have to make a decision. You can't be like a blurred line between them. So I'm finding your response to be a blurry to me, and trying to blur that line. It's very clear what the law says with regards to the role of the city attorney. Now, if there's case law that is refuting that, well, then let's settle that and say, well, what role does the city attorney play with regards to the supervisor records of that part? Now, I don't want to go down a rabbit hole too much here, because this is really discussion. If this goes to the task force, just trying to get some clarification to help the task force understand your argument here. Thank you. And you can respond to that if you like.
Thanks. Yeah, I understand your line of questioning, and I understand that. I think ultimately for us, what we are following is the St. Croix decision, which is that the Sunshine Ordinance cannot supersede our duty as the city attorney to, when there is a conflict, our duty to provide advice to our clients, and cannot dictate how and what advice we provide to our clients.
Okay, thank you.
Thank you.
Okay, my turn. Can you, I'm going to again go to the respondent here, but I do have one or two questions for the petitioner. Ms. Court, can you envision any situation where the city attorney would not feel like it was bound by the charter and was not going to have the ability to issue an order, as we've been discussing?
I'm not sure I totally understand, but do you mean, can I envision any situation in which the supervisor of records would order a department to do something?
Exactly.
Yeah. I think truly that's very hard for me to answer without a specific situation in mind. I don't know. I'm struggling to answer that, but I don't think that
So
the
you wouldn't
supervisor of
say,
records would fully rule that option out ever.
okay, but you're not going to say here today that there could never be such an order. You're not taking that position yet, right?
No, I don't think we'd be comfortable, the supervisor of records would be comfortable ruling out taking that action entirely.
Okay. And when you said, I did hear you use the word conflict.
Mm-hmm.
And so I'm going to somewhat parse words here because this is a little bit of a gray area that we're dealing with. But when you said conflict, would you stretch that to say that the city attorney believes it has a conflict of interest in this situation?
No, I think that was just me talking, not necessarily something inherent about a conflict of interest. I think that's just my word choice in the moment.
No, the word's fine. I believe you were saying that the duty to advise is deemed to conflict with this idea of issuing an order.
So I think,
and I understand that argument. I'm just trying to see if the city attorney's office has gone through what I'm going to call a conflict of interest analysis and seen that it has some kind of a conflict of interest per all the ethical rules that attorneys have to follow.
I don't think that we have a conflict of interest because we do have an interest in getting the public information that is their right to have, that it is their right to have these public records. I don't think we have an inherent conflict of interest in, that goal is also our goal. So I don't think that we have a conflict of interest in that way. And I think that our approach, or the city attorney and the supervisor of records approach to this thus far, has been to do as much as we can up until the action of ordering to get these records to members of the public.
Okay. Question to Anonymous. There was a sort of just a little reference in one of, I think it was on page 98 of our record. You said that the city attorney's office uses the term quasi-judicial to explain what it's doing here. Could you tell me what context that's in? Where did they say quasi-judicial?
Yes, it's on their supervisor of records. It's on the city attorney's Sunshine Appeals page, which explains how to file a supervisor of records appeal. And when I first started filing these complaints, I actually web.archived it so they couldn't change it after I spotted that. And I'm happy to produce a copy of that into the packet.
Okay. Okay.
I'm sorry. Could I just say one thing about the website?
I'm going to give you a chance in just a moment. And I want to also ask you about that reference. But let me just finish up with Anonymous here. So are you, Anonymous, are you saying that the quasi-judicial language was somehow eliminated and it's not on the current version?
No, the current version uses quasi-judicial. It still uses it to describe their process, but it just uses it in, I believe, a different paragraph. I believe it was more prominent in the past, but it's still there. So
okay. And do you have any sense of what they would mean when they call themselves quasi-judicial?
I can't. If you're asking me if I know legally what quasi-judicial means beyond my layperson's guess, no, I do not.
Okay. And now I will turn to the respondent. And I know you. I'll give you a chance. You wanted to say something about what I had asked Anonymous, so I'll give you a chance to say what you wanted to say first.
Sure, thank you. I just want to make just two things clear. One, I've been in this role since November 1st of last year. Me and one other person administer the website. So I just want to be clear, from the time of November 1st of last year, the website has not changed on that page whatsoever. So I just want to be very clear about that.
Okay.
On that note, I do think that we fully accept and recognize criticism that language it doesn't accurately reflect how the supervisor of records, the city attorney Chu, see their role. And so I wanted to say, in a public forum, we would like to actually change that language because we don't feel it accurately reflects how we approach this role. So I just want to say that.
Yeah. I completely agree with that. That needs to happen because it's confusing to a lawyer. I'm an attorney, and this is what I do, and I don't understand how that language would show up there. And so, I understand people use words and then they realize, oh, maybe I should have said it differently, but I think that's where we're at here. And I'm glad you acknowledged that, because I was trying to figure out what are they talking about?
I think that's fair.
Is this a role that I've never heard of? But thank you. And because this is, and I know that one thing I want to make sure we have when this goes to the full task force is that we have our own wing of the city attorney's office. And I know this has come up with them before, but I think that I want them to be ready to talk about this, because I think that there's something here that just doesn't work quite right. I think there needs to be some kind of a declaration that an order will never be issued, and it maybe we need to say it, because it certainly appears that an order would never be issued here. But I digress. Okay. Any other questions?
May I, given that?
Yeah, please. Go ahead.
Okay, I would like to respond about a comment St. Croix. If I could also have that question, I would like to respond, given that she has had a chance to respond as well.
Yeah, I'll give you that chance. Yes.
Okay. So I think that I believe the respondent's representative here is not, I don't think she's herself a lawyer, but last time they did this, they gave, their legal analysis of why you shouldn't find a violation in the 10-day case, right? And I think if they're going to cite that court case, they should give you quotations, line and verse, from that court case that compels you to rule against me. Because if that's true, then you should rule against me. But I don't think that they're expanding the scope of St. Croix beyond what is actually in the text of St. Croix and is a holding by the Court of Appeals. And I don't believe under the Constitution, under Prop 59, you can expand any ruling that would reduce my access to public records beyond what the court has said. And I also don't think the task force has the authority to basically invalidate a provision of the Sunshine Ordinance unless the court itself says it is invalid. So I would invite the respondent and hope they produce to you in written form a legal argument citing exactly where it is in St. Croix that would prohibit them from giving an order when they determined that the custodian did not follow the law, right? And how that conflicts with a charter responsibility or attorney-client privilege or whatever else they're arguing. Thank you.
Thank you. Very on point there. And I don't myself see that St. Croix can be as broad as to encompass what they're saying it encompasses here. And so we want to, at the task force itself, we want to talk about that a little further. It would be helpful if they can be, because I'm not sure if they can be a little more clear about what they, how they think there's a problem here based on St. Croix. Because I haven't seen it.
Yeah, I was, before that comment even, I was just going to suggest to Ms. Court that you consider putting that case and the specific citations that you believe are applicable here into the packet as part of your response.
Understood. Thanks.
I have a question.
Yeah, Member Wolf.
This is for the respondent. So, and I'm wondering, because I don't know, I'm just not quite feeling solid on both sides. I'm just trying to get as much clarity here. If a city staffer were to be found in violation of any law while in the course of their work, including but not limited to reportable actions to law enforcement, is it not the duty of the city attorney to take action? Or would the city attorney automatically just become their defense counsel for that staffer?
I'm sorry. Are you referring to a violation of civil law or criminal law?
Well, the question becomes is where does the city attorney have a role in reporting any city staffer or elected official or commissioner, appointed official, to law enforcement if they break the law? If that law requires such reporting.
So I think any requirements and obligations that we have under the law to report someone to law enforcement, we would certainly fulfill those things. I don't think it's a secret that we represent, the litigators in our office represent employees, city employees, who are sued civilly when they are acting in the scope of their employment. So we would be their counsel in that instance. Okay,
so if you were under obligation by the law to make a reporting to law enforcement, and the law specifies that you can do that, wouldn't that be applicable here?
I don't necessarily. I think there's degrees of severity that we're talking about, and certainly if we see there's an obligation to report something to law enforcement or refer something that's a criminal action to the district attorney's office, we would fulfill that obligation.
Okay, thank you. And can you explain if the city attorney, who the city attorney actually represents? Do they represent the people who are also its government, or only government as an entity and its officials and staff?
There's a couple of kind of unique instances here, but for the most part, the city attorney is the counsel and the representative to city officials, city departments, agencies, city bodies, and then if someone is sued civilly, an employee is sued civilly, and it has to do with conduct in the scope of their employment, we would be their lawyer. In affirmative litigation cases, which we can sue on behalf of the people of the state of California under the state's unfair competition law. That mostly has to do with business actors, though, not necessarily individuals. So I'm sorry, that's a long way to answer that. But
I didn't hear the city and county of San Francisco in your response.
Oh, yes. I'm sorry. We do represent the city and county of San Francisco.
Okay, thank you. Mr. Chair, I think the question before us is really right now is whether this complaint is within our jurisdiction or not. And I think we pulled enough, I feel we pulled enough information now. I would be good for helping. If this were to go to the task force, we have enough information to provide a good review and briefing for the task force members. So I'd like to move forward with that process.
I think we're all done with our questioning. I don't want to. Member Stein, are you set?
Yeah, I have no other questions.
Okay. So, Member Wolf, go ahead, make a motion. Do you feel like this should move forward? Do you have a recommendation?
I move to I move that this is within the jurisdiction of the Sunshine Ordinance Task Force, as stated in 6721D, as reference, and move it to the task force for scheduling for hearing.
I'll second that. This is Member Stein.
Can you give me one moment? Okay. It's moved to find that the task force has jurisdictions as stated within 67.21D and to refer the matter to the SOTF for hearing. Before we move on, there was an initial question that I brought up in the beginning of the hearing. Is there any need to make any changes to the respondents listed in my title?
I believe that if there was a complaint against anyone other than Dennis Herrera, Anonymous has already waived such, and I saw that in the file. It's pretty clear. I don't see that it should be against anyone other than Dennis Herrera. Does anyone have any other thoughts on that?
Not at this time.
No.
Victor, does that sound all right?
Yes, I will so adjust the title.
Anonymous, is that accurate?
Correct. Dennis Herrera is the sole respondent. I have dropped the office of the city attorney as respondent.
Okay, that's it.
Okay. The motion has been made. I'd like to find out if there are any members of the public who would like to make public comment at this time. You can press *3 to raise your hand, or otherwise use the application to raise your hand at this time. I will give everyone a few moments. I don't have any hand raised yet. Okay, I do not see any hands raised. Would you like me to move on to the vote?
Yes, please.
Yes, on that motion, Member Wolf.
Aye. Aye.
Wolf, aye. Member Stein.
Aye.
Stein, aye. Chair Schmidt.
Aye.
Schmidt, aye. The motion passes without objection. Moving on to our next item, which would be item number 6, file number 22107, complaint filed by Peter Warfield and the Library Users Association against the City Librarian Michael Lambert and the Public Library for allegedly violating Administrative Code, Section 67.29-5 by failing to respond to and provide the Proposition G calendar in a timely and/or complete manner.
We have a representative on behalf of the respondents present.
If you can raise your hand. Oh, okay. I have one. I'll unmute them at this time. And I will go ahead and unmute Mr. Warfield's line.
Okay.
Would the representative like to announce themselves just to be sure we have you?
This is Margot Schaub with the library.
Thank you.
Thank you.
I will just point out before we begin with Mr. Warfield that it looks like the respondents are not contesting. So that may affect how we handle this today. But with that in mind, when the timer's ready, we can hear from the petitioner.
Okay, give me a moment. Let me get my timer back up. Okay, Mr. Warfield, you should be unmuted and you can begin your comments at your discretion.
Okay, Peter Warfield, Library Users Association. Am I starting now then?
Yes, please do.
This is a very straightforward and I think very simple complaint having to do with the lack of a timely provision of the July City Librarian Prop G calendar. I'm not sure why it takes 200 pages. The contents were not available to us at the time we made the complaint, and it's fairly straightforward. I'll go to the summary that we provided on October 13. It's on your page 158. Basically, it's very straightforward. We're asking you to find a violation of Sunshine 67.25, the immediate disclosure request, and 67.29-5 regarding prompt provision of Proposition G calendars. And we're also asking you to really probe what went wrong, because I think that the response of the respondent is extremely vague. There's no specificity as to what happened or why, and I think it's extremely important to understand what happened, and especially because there was reference to confusion. And what confusion was there? Was it the wording of the law? Was it it's not clear at all what went wrong and how they fixed it. So on Tuesday, September 13, which is on your page 128, we filed an immediate disclosure request and requested on a rolling basis, if necessary, to receive the July 2022 Proposition G calendar for the city librarian, with a copy to Margot Schaub. On Wednesday, September 14, the next day, page 129, we received a reply from the city librarian through Ms. Schaub. Nothing in the way of documents was provided. We heard that this wasn't really an immediate disclosure request because it was, well, you can look into that if you like. That's page 129. And they said they would provide the calendar no later than October 3rd, which is 20 days after our request. That was a little alarming. That didn't seem justified under any circumstances at all. Thursday, September 15, with no documents provided by mid-afternoon on page 125, we filed our complaint and request for hearing regarding this matter. Subsequent to our filing the complaint, which included our complaint, our request, and the initial reply, Ms. Schaub's initial reply. Subsequent to this, on Friday the 16th, late afternoon, we received a presumably a July 2022 calendar totaling about 137 pages. We hadn't received this at the time we filed a complaint, and so the complaint doesn't include content unless for some reason it comes up in the discussion.
The time has elapsed.
And September 29th, they said that they had were confused and had been in the wrong and had fixed whatever problem it was that they thought they had.
Okay, thank you. Now we can hear from the respondent side.
I don't have much more to add. I don't have much more to add than the letter that we submitted. There was some confusion about responding to the request, and we are taking steps to fix how we respond to Prop G records requests.
Thank you.
Sure.
Okay, members, questions?
This is Member Stein. I just want to clarify with the petitioner. So you received the documents on what date?
We received presumably the July 2022 calendar at late Friday afternoon, September 16th.
Okay. All right, so I'm just checking that. And then for the respondent, I'm wondering, because the Prop G calendar, it seems like a calendar that is specifically prepared to be shareable with the public. So I'm wondering, why is it something that needs review at all if it's prepared according to the specifications of a Prop G calendar?
I can answer. I don't do his calendar, so he and the person who does his calendar had worked out how they were abiding by the Prop G calendar requirements. And so when we got the request, that was the first Prop G request I had received in my role, and his calendar was Prop G compliant. However, in the calendar are also proprietary phone numbers and some additional information. So I needed to go through and take out all those. I had to redact the proprietary phone numbers and, with the Teams call and all of that type of stuff, and any other information that required redacting. And it takes some time.
Okay, thank you.
Mm-hmm.
I got a quick question. What's a proprietary telephone number?
So Teams calls and Zoom calls, you get phone numbers to call in for that meeting, and then you get passwords for that meeting. And so what we have been advised throughout COVID is that not to release those phone numbers, because then people can use them again and again, and then someone from the public could get it and call into a meeting that's not open to the public.
Okay, got it. Thank you. Thank you. And there may be other questions for the other members, but I just want to interject a question. Mr. Warfield, what can we look at in terms of, you had an issue at the point where we were talking about agenda changes, and is there some change that you wish that anything that we send forward reflect?
Well, we sent an immediate disclosure request, and we did not get any substance of any kind, not even a single day or a single entry, by the next business day. And we were told that they were going to take 20 days, as much as 20 days, which doesn't comport with an immediate disclosure request or a Prop G calendar. That was actually kind of alarming. To talk about confusion, that seems like there was some confusion on their side altogether. And as far as redactions, there's nothing in the Prop G calendar that requires redactions. If they choose to put stuff in for redactions and then use that as an excuse to delay the response, I think that is very, very wrong. They should have a calendar, Prop G calendar, 3 days after the date, according to the law. And the law doesn't talk about provisions for extra time for this, that, or the other thing. Everything that's required in there to be turned over is public.
So you want us to consider the IDR compliance and the calendar issue, And you also want us to be looking at the redactions when this thing goes forward, correct?
I have not asked for you to look at the redactions. I view that at the point that I made the complaint and afterwards that might be a separate issue and a separate complaint. But this one, I was prepared for the timing issue only.
Okay.
And again, talking about confusion, the idea that they say they are going to provide a calendar not later than October the 3rd, which is 20 days after our request, there seems to be a lot of confusion when in fact there is very simple. It's very simple. An immediate disclosure request is something that's been on the books for 20 years. We've had many, many, many requests, and they've responded many times. And the calendar, the Prop G calendar, is something that also seems to be a fairly straightforward and fairly simple thing that's been on the books for quite some time.
All right.
And if we haven't had that experience, it is our first request from them. I don't know if that's their first experience of Prop G calendars, but surely they have legal advice. They have the law that they can look at and read. It's not that lengthy. It's less than a page, I believe. Seems like it would be really straightforward, and I think that it's important, especially in light of your advisory role, to find out and to probe, as we said in our letter of October 13 on page 158 and 159, what happened, what went wrong, and what might you do about adjudicating what happened and what you think of it.
Thank you.
Yeah.
Okay. I think that when we send this forward, I believe that and we'll do this when we talk about resolution, but I do think that we can consider the redaction issues, even though it wasn't known about at the time you filed your complaint, because it has to do with the subsequent production. Okay, any other questions, members?
I guess I have one question for the respondent, which is that do you only keep one calendar, or do you keep a separate Prop G calendar as well?
At this time, there's one calendar, and it's a Prop G calendar. However, it does have information in it that needs to be redacted. And so we're taking steps to do that so it is ready within when we get a request.
Okay, so what steps have you taken so that it can be available within 3 days?
We're going to either create 2 calendars or redact every day after the meetings are done the next day. And so the calendar will be ready to go.
Okay. Thank you.
You're welcome.
Okay. Any other, I don't have any more questions for the parties. Unless Member Wolf has anything, we could move on to figure out, and we do want to consider whether we want to send this on a consent basis.
Well, I do have.
Go ahead.
Yeah, just a quick question for the petitioner. Mr. Warfield, your complaint is against Michael Lambert and the public library. Is that correct? Or is it just Michael Lambert?
I'm not sure how we phrased it, but in general, the department head specifically is responsible, as I understand it. Functioning as the department head, the department, it seems to me, is responsible as well.
Okay. All right. I don't have any other questions at this time.
Okay. All right. So at this point, we can talk about whether we want to move this forward. I'll note that, yeah, it looks like the timing issue is not a contested matter. There may be an issue about whether it was proper to say that it's not a proper IDR. And there may be some factual issues about the propriety of the redactions. We could either send it forward with those in whatever recommendations we make, or we could send it forward with those and put it on a consent calendar.
My initial thought was to recommend moving it to a consent calendar just for the 67.25, not responding to an IDR in a timely manner, and the 67.29-5, that violation of that the calendar should be available in 3 business days. The redactions aren't really addressed in this packet. And the petitioner is not really asking us to look at the redactions. And since the library does not contest this violation, my first thought is that it would be appropriate for a consent agenda, and doesn't necessarily need a full-blown SOTF hearing. So I will make a motion to that end, and we can decide.
If I can, before, was that a motion?
That kind of was a motion, but if no one seconds it, then.
Okay, I'd like to just discuss for a second, because I don't find how the library itself is responsible for a Prop G calendar. Prop G calendars are specifically to the department heads and public officials, and it's their responsibility or their staff's responsibility, what have you. The responsibility is on the person who the calendar is being held for. The public library in and of itself doesn't have any responsibility for a Prop G calendar. It's a personal thing for a particular named position. So in moving the motion, I would like to have the public library excluded. That's it.
Yeah, and I'm fine with that. I'm looking at 67.295, and it's pretty clear that it's referring to particular department heads or members of the Board of Supervisors or certain city officials. So I would be fine with that. So I would recommend moving it to the consent agenda for these violations, 67.25 and 67.29-5. And I don't know, how do I put in, with respect to whether Michael Lambert violated these sections of the Sunshine Ordinance.
Yeah, just against
Michael Lambert.
Yeah, I'll second
that. Just to restate for the record, moved by Member Stein, seconded by Member Wolf, to find that this SOTF has jurisdiction, find that the requested records are public, and refer the matter to the SOTF consent agendas for violations of 67.25 and 67.29-5 against Public Librarian Michael Lambert.
Correct.
Mm-hmm. Okay, would you like to move on to public comment at this time?
Yes, please.
Are there any members of the public who would like to provide public comment on this matter? You can raise your hand by pressing *3, or otherwise indicate you have raised your hand through the application. I believe we have anonymous number 3 who'd like to make public comment at this time. Just getting my timer up. Anonymous, you may begin your comments.
Thank you very much. I agree with the members that the violation is personally the responsibility of each department head. I know I've discussed this at SOTF quite a bit. You don't get to kind of delegate your violation to your, amorphous agency. You have a personal responsibility. And that's not just for the calendar itself. It is, the general requests can be made to a person having custody of a record. And so even on that, this makes sense. I will point out, I haven't looked at the calendar myself, but on February 10th, 2020, in my first audit of everyone's property calendars, Michael Lambert stated, this is 2.5 years ago, "Thank you for making me aware that my calendar lacks sufficient detail in that some meetings lack statements of issues discussed. Moving forward, I'll work with my executive assistant to ensure we include more information concerning the nature of future meetings in my calendar." And therefore, if his calendar does not currently have all the general statement of issues discussed under 6729-5, I would encourage you to send this to the compliance and then to the Ethics Commission for a willful violation of the property calendar law. Thank you very much.
Thank you. Any other public comment?
I keep doing that to myself and forgetting to unmute. Are there any other members of the public who would like to make public comment? You can raise your hand. I'll give everyone a few moments. Okay, seeing no additional hands raised, I believe we can close public comment. Would you like me to take the vote at this time?
Yes, please.
On that motion, Member Stein.
Aye.
Stein, aye. Member Wolf.
Aye.
Wolf, aye. Chair Smith.
Aye.
Smith, aye. The motion passes. The matter will be forwarded to the SOTF consent agenda.
Next matter when you're ready.
Okay, moving on. Give me one moment. I'm just going to clear everything up. Okay, next on the agenda is item number 7, complaint filed by Marie Shulman against the Office of the City Attorney for allegedly violating Administrative Code Section 67.21 by failing to respond to a request for public records in a timely and/or complete manner. I believe Ms. Shulman is here. I will go ahead and unmute her. And I don't know if Ms. Quirk is also representing this matter. Oh, not Quirk. My apologies.
Yes, I am.
Okay. We have our two parties present.
Okay, we do. All right, and I've made this disclosure before. Ms. Shulman is a friend of a friend. I've met her on a couple occasions. I've talked with her, but I don't have any conflict or reason to think that I can't be a neutral decider in this matter. Okay, so when Victor's ready, we can hear from Ms. Shulman for up to 3 minutes first. And of course, as you know, we've read the written material, so no need to go back over that. It's just anything cogent that you want to talk about.
Okay, Ms. Shulman, you can proceed at your convenience.
Okay, you can hear me?
Yes, I can.
Okay, great. So thanks for hearing my complaints. I guess you can see in the documents the request was made on September 30th, 2021 through email. And I received a set of documents on October 26, 2021, but one of the records that I had requested was missing. And the respondent claimed to have included that record in what was delivered on the 26th. But I don't think that's true. I think it's demonstrably false. And the respondent didn't provide that record until the next day after I had made repeated requests and pointed out that the record was missing and what was delivered on the 26th. The respondent claims that questions of whether or not the records were delivered in a timely manner are moot because they eventually provided all the records. But the respondent failed to provide rolling records and instead, I think, attempted to withhold public records that were responsive to my request until all potentially responsive documents had been reviewed and collected. And I think that's a violation of Section 6726. And I'm still missing some records. The respondent never provided me with the email correspondence that I requested, items 1, 2, and 4 in my initial records request. And they completely ignored my written request on October 26th for a personal search of one person's email. And and the respondent also admitted in writing to have intentionally withheld certain records and said that I should request those specific records from the Superior Court instead. And that's all I have to say.
All right, thank you, Ms. Schulman. Now we are ready, when Victor's ready, to hear from Ms. Clark.
You may begin at your discretion.
Thank you. Thank you, task force members, for hearing this. We, as the petitioner said, we received a public records request on September 30th. Within the initial deadline to respond on October 12th, we invoked a 2-week extension under Government Code 6253C. And in that October 12th communication, we explained that we would respond by October 26th. On October 12th, the complaint was filed with the task force. And then on October 26th, we responded with hundreds of pages of responsive records. In terms of the transcript that was originally, that the petitioner said was originally missing from the production, that was not an intentional act. As soon as the petitioner pointed it out to us, we responded the exact same day with that hearing transcript on October 27th. We pointed out, in terms of the court filings, we pointed out that it would likely be quicker and more efficient for the petitioner to request the publicly filed court pleadings from the court. However, when the petitioner asked for the filings from our office on November 10th, we sent those pleadings on November 16th, all that were in our possession. And then in terms of other records that we are continuing to withhold, those are all exempt under disclosure under attorney-client privilege and attorney work product privilege. So with that, I'm happy to take any questions, but we did, work pretty hard to fulfill this request. We produced hundreds of pages of responsive documents and complied with all the procedural timelines. So thank you.
Thank you. All right, any questions, members?
I have a question.
Yeah, Member Wolf.
Ms. Court, so when you say that you're withholding records under attorney-client privilege, the withholding has to come with some citation of law and with some like specificity of the of like why this document applies to that. Now, I hear you saying that it's attorney-client privilege, but the question then becomes, is the record public? And if the record is public, even though it's being withheld, that helps us make our decisions.
I understand. All that I can say to that is that on October 27th, and I believe before that on October 26th, we did cite all of the relevant codes for why we were withholding those things for attorney-client privilege and attorney work product privilege.
And did you submit that for the record here?
Yes, all of that email correspondence should be in your packet.
Okay, very good. Thank you. That's all I have for the moment.
Okay, just one question to Ms. Kavort. Just kind of like a small part of the matter is about, you referred petitioner to the Superior Court because those are publicly available filings. And I know that that's something that's valid if you're in a litigation context, civil litigation. I'm just wondering if that's something that you can tell me is a way that you can comply with a records request in this context? Do you have any kind of like legal authority for that, in other words?
I'm not sure I quite understand the question. I'm so sorry.
I'll try to ask it better. Um, if a document is available elsewhere, does that entitle you to direct someone elsewhere if your agency has available copies of that document?
I cannot speak to the legal authority of that. I just want to be clear. I do not know the answer to your question, but I do think that what we had within our attorneys had in their files would have taken days to go through and ensure that they were properly redacted. And we thought it would be more efficient to get it from the court, and that they would have, it would just be quicker for the respondent. But when the respondent made it clear that they wanted what we had from us, we responded 6 days later with what we had.
Okay. Very good. Thank you. Nothing further from me. So members, if you have any more questions, that's fine, or else we can decide what to do with this.
I have one more question for the
sure.
respondent. Ms. Wirt, you had mentioned that you invoked a 2-week extension under the California Public Records Act. Is that correct?
Yes, that's right.
Okay. Are you stating that the Sunshine Ordinance does not supersede that?
I'm not sure. I don't know the answer to that. I know that we invoked that 2-week extension because the amount of records that we had to examine were voluminous and in several different places.
Okay. So how do I put this? The California Public Records Act allows local agencies to create additional laws to increase efficiency and expediency of the disclosure of public records. That is how the Sunshine Ordinance came to be, how the San Jose Ordinance came to be, I think it's Oakland or Alameda County, how theirs came to be. And those enhancements then are what is the law within that jurisdiction. So for us, this was, I don't think this was an IDR. And despite that, under 6721, the whole section, well, you could just start with 6721B. It starts off by saying a custodian of public records shall, as soon as possible, and within 10 days of receipt, following a receipt of a request for inspection or copy, to comply with such request. There is no extension. The only time that there is an extension allowed is under 6725, which would be the IDR, because it's requesting a response by the end of the following business day, and if the record is not available, then a 10-day extension could be made. So that's what, it triggers us every time we hear when somebody invokes the 2-week extension. If you had made some arrangements directly with the requester that, this may take us a couple of weeks because, it's a lot of information, or we have to dig it out of Iron Mountain or something like that, then that's a different story. That has nothing to do with the ordinance. That's just something between you and them. And then if for some reason you decide not to comply, well, then that offers us a different outcome. So I just wanted to point that out. Do you feel that the law reads something differently?
I might want some more.
I don't think I can answer your question, but I'm happy to follow up.
Okay, thank you. That's all the questions I have, Mr. Chair.
Okay. I think it looks pretty straightforward to me. It does look like we can't make any decision in terms of the timing, the delay issue, because that would be something that the task force would determine. We can make a recommendation or not. I think we also want to make it clear that there also appear to be outstanding remaining documents. And so at the task force level, it should be considered whether to order further production. And assuming Ms. Schulman is interested still in getting those documents, that, you know, I think that she should pursue that, and we may be able to order that at the task force. So any motions, members? That's just my thinking on it.
You're muted at this time.
Well, that's good to know. I just want to point out that this request and even the time frame for its fulfillment pretty much occurred when the mayor's fifth supplement was in order, suspending some of the provisions in the Sunshine Ordinance with respect to time, but leaving the CPRA provisions in place. So I just want to mention that so that we don't kind of lose sight of that.
I appreciate pointing that out. I
Very good. Very
realize
good. Yeah.
the date on this one.
Mm-hmm.
Thank you. So my apologies for any directness to the respondent on that. Thank you.
But even so, it does, like, to me, it does appear that the documents may have been at least a couple days late, even by CPRA standards. So, you know, I would be willing to make a motion that these are public documents under our jurisdiction, you know, that we forward it to the task force to consider a violation of, I think it would be 6253C in this case, which is the time factor in the California Public Records Act, and also the question of whether internal correspondence was properly withheld.
Okay, I got part of that. I just want to get a confirmation of what you want the task force to consider.
Whether it's a violation of, I believe it's 6253C. I would have to just.
6253C.
Yeah, that is the. I believe that is the time frame given in the California Public Records Act, and I can just double check it, and also to consider whether some documents, internal communications, were properly withheld.
Okay, give me one moment. Okay, do we have a second?
I'll second that.
Yeah.
Okay.
Fumbling with the mute key. Sorry.
Okay, just to restate. The action is moved by Member Stein, seconded by Chair Schmidt, to find that the SOTF has jurisdiction, find that the requested records are public, and refer the matter to the SOTF for hearing for consideration of CPRA 6753C for timeliness of response.
6253C.
6253C.
Mm-hmm.
For time frame of response and consideration of proper withholding of documents.
Yes.
Okay, if there are any members of the public who would like to make public comment on this item, you can go ahead and raise your hand by pressing *3 or otherwise raising your hand. We have anonymous number 3 in line. Let me get my timer up. Okay, Anonymous, you may proceed at your discretion.
Thank you very much. This is Anonymous number 3. One of the points, obviously I agree with the motion. I don't believe the rolling response requirement was purportedly suspended by the mayor. So I think when this goes eventually to the task force, you should look at that. And the reason I say that is the city attorney's office is notorious for not doing rolling responses. They'll just wait months and then give you everything at once. At least that's what I've experienced. And 6725B was not suspended as far as I know, or not even purported to be suspended by the mayor. And I also think that Chair Schmidt's point, this task force has now multiple times found the city attorney's office in violation, not necessarily under Chu, but under Herrera, but it's still the city attorney's office, for doing this thing with court documents. The Sunshine Ordinance is very clear. You can refer them to some other agency if you don't have a copy of the records. But just because they don't want to do work doesn't mean you can refer them to someone else and put the work instead on someone else. It's only if you don't have. I'm happy to go find that section of the Sunshine Ordinance, but that's allowed when you don't have a copy, and they've done this in the past also to basically put the work on someone else. I would say I don't really understand why the city attorney's office sends and has, under the prior city attorney and the current city attorney, non-attorneys to this task force who then have to answer to you, I don't know, I can't tell you. They're the one place who should have experts on Sunshine Ordinance law and who should be able to send a lawyer here who can actually accurately, to their own position, respond to your questions. I'll never understand why they send a PR person here, which is always who they send, instead of a lawyer. It just doesn't make any sense. Thank you.
Okay. Are there any other parties who would like to provide public comment regarding this matter? Go ahead and raise your hand. I do not see any additional hands raised at this time. Would you like to proceed to the vote?
Yes.
Okay, on that motion, Member Stein.
Aye.
Stein, aye. Chair Schmidt.
Aye.
Schmidt, aye. Member Wolf.
Aye.
Wolf, aye. The motion passes without objection. Next on the agenda is item number 8, file number 21145, complaint filed by Maria Shulman against Sarah Mander and the Department of Police Accountability for allegedly violating Administrative Code, Section 67.21 by failing to respond to a public records request in a timely and/or complete manner. Ms. Shulman is still with us, and we have, I believe, a user. Hello, caller. Are you here representing the Department of Police Accountability?
Yes, this is Sarah Monder.
Give me 1 second. I got extra noise for my timer that I forgot to turn off. And could you state your name again?
Sarah Monder.
Could you spell your last name, please?
Maunder.
Got it. Thank you.
You're welcome.
I defer to Chair Smith to proceed.
Yeah. Ms. Shulman, you're up when Victor's ready.
You can proceed at your discretion.
Great. So I submitted a request to the Department of Police Accountability, and I submitted it online through their Next Request portal on October 3rd, 2021. And the respondent failed to provide rolling records and instead withheld the responsive public records until all the potentially responsive documents had been reviewed and collected, which I believe is a violation of Section 6726. And at several points, the respondent writes that they've identified records but will not release them immediately. The respondent did produce some records on October 27th and November 22nd, December 6th, and December 10th. And they declared that the records request was complete. On Next Request, they closed it. But there's at least one record that the respondent has not produced. And the records that were produced by the respondents were only produced after I had made multiple follow-ups and after I filed a complaint with the Sunshine Task Force. And think that I should not have had to go to these lengths to obtain the records. It would have been much more efficient if the respondent had simply promptly and thoroughly responded to my records request. And that's the end of my statement.
Thank you. Okay, when Victor is ready, Ms. Munder.
You may proceed.
Thank you. We did submit a response to this complaint, which was filed pretty close to the time the request was made. And then I tried to submit a follow-up response last week, but I missed the deadline for getting documents on the agenda. We have sent, since this complaint was filed, we have sent a total of 134 records, including media records, hundreds and hundreds of pages of documents, which we provided on a rolling basis and in a timely manner, aside from one time when we were a day late. So we made, let me see, I think 6 productions total, so 6 batches of, it was either 5 or 6 batches of files produced, and all were timely except for one, which was one day late. That's it. Thank you.
Okay, thank you. I want to start just by asking Ms. Schulman, what is it that hasn't been produced yet as far as you can see this?
I think that I'm missing a transcript of an interview that took place in 2019.
Okay. Who was interviewed that? Do you know can you identify that a little more, or is that
Yeah.
Okay.
I think the respondent mentions it at one point but it was an interview between SFPD and an individual person, and
Okay.
I told them the date that it took place.
And that didn't come in last week.
I don't think so, but
Okay.
I
Did you
haven't had
get
a
something?
chance to look through everything.
Okay. You haven't had a chance to look through. Ms. Monder, is there a chance that document has not been produced, can be produced, or is there a reason it shouldn't be produced?
This was produced on, it's the 69th document that we produced on a total of on December 6th, and it was called WJ190462-Claire O'Hoyne -pilot _VDD _ a whole bunch more numbers. Because of the huge volume and size of files, I was not able to submit them. I wasn't sure where to submit them to, but they have been provided, and I can reprovide that transcript.
Okay, thank you. Members, any questions for the witnesses, parties?
Yeah, Mr. Chair, just to clarify that a little further, for either the parties on page 742 of our agenda of this file, there is a response from the respondent on October 12th, 2021, and it reflects a transcript of a recorded interview between Claire O'Hoyne and Officer Crockett in 2019, quote unquote. Is that what we're focusing on here as the missing document?
Yeah, that's what I was asking for.
Okay, great. And Ms. Munder, is this the record that you're referring to?
Yes.
Okay, very good. Thank you.
Okay. I'm not sure if, I don't think we have any further questions. So what would the members like to do with this?
Well, I'm still not clear if the respondent says that they did deliver the document, that transcript, and the petitioner didn't receive it. I'm not. Is this just purely a timeliness issue because it came later, because the respondent didn't have a place to post it or send it at an earlier time? Is that kind of the gist here?
It does seem to be just a timeliness piece. Are you asking the question of the petitioner or the respondent? Because I'll just say, like, on my reading of this file, you know, the initial request is made 10/3. Documents are provided on a rolling basis. Everything is eventually provided by the date of December 8th. So it's a little over 2 months.
Okay. That answers my question.
Yeah, I think that assuming that there's not an outstanding document, it seems like everything has been produced and there hasn't been anything about the production, the quality of the production that's at issue. It seems like we're talking about time here. And so we would go forward to the task force. That would be the issue that's here.
And also the issue is that the respondent does contest that there was a time factor. So we don't have agreement on that. I also want to point out that this, again, is much of this happens during the 5th proclamation, which suspends the time factor on, you know, on the Sunshine Ordinance, but not the CPRA.
Yeah, we're not deciding it, but it may be that we have to figure that one out, but we'd figure that one out later in terms of which way to fall on that.
Okay. So, I mean, I can make a motion that these are public records under our jurisdiction and to forward it to the task force to consider whether there was a violation in timeliness of record production.
I'll second that motion.
I keep doing that, forgetting about my mute button. Give me one moment. Okay, we have a motion moved by Member Stein, seconded by Member Wolf, to find that the SOTF has jurisdiction, find that the requested records are public, and refer the matter to the SOTF for hearing regarding timeliness of record production. Are there any members of the public who would like to make public comment on this motion? You can press *3 to raise your hand at this time. Okay, we do not have any additional hands raised. I believe we can move on and close public comment. Okay, on the vote on the matter. Member Stein.
Aye.
Stein, aye. Member Wolf.
Aye.
Wolf, aye. Chair Schmidt.
Aye.
Schmidt, aye. The motion passes without objection. Excuse me. Moving on to our next item, item number 9, file number 22110, complaint filed by Anonymous against Supervisor Matt Dorsey for allegedly violating Administrative Code Section 67.21b by failing to respond to a records request within 10 days, 67.25 failing to acknowledge an immediate disclosure request within 1 business day, and for violation of Government Code 6253C for failure to respond to a public records request in a timely manner.
Okay, it does look like this case is there's an admission, but apparently I don't know if there's any issue as to whether there's records or not. They say they don't have any, but they admit they were late. So it may be that would belong on a consent calendar. Do we have anyone here on behalf of Matt Dorsey?
Hello, yes, my name is Brian Dahl, Legislative Aide for Supervisor Matt Dorsey, District 6.
Okay.
Thanks for hosting me tonight.
Okay, I'm gonna put you just on hold for a moment because we're gonna give you up to 3 minutes, but we want to hear from the petitioner first.
Yes, sir.
So let's do it in that order. Thanks. So when you're ready, Victor.
Yes, Anonymous, you may go ahead and proceed with your comment.
Excuse me. Thank you very much. This is Anonymous number 3, the petitioner. I think this is a very straightforward case. Many years ago, Matt Dorsey was not a supervisor and was not the head of communications for SFPD, but instead he had the head of communications job for Dennis Herrera at the city attorney's office. And during that time, he argued before this task force why the supervisor of records law, in fact, the issues we just discussed in the very first complaint, you should not find a violation by Dennis Herrera. You then instructed Herrera's office, the task force, obviously it's a different set of people, instructed Dennis Herrera after finding him in violation to provide written records of the procedures used for the supervisor of records process. And I requested those. The respondent admits they did not comply with the timeliness requirement of the law. And so you should find violations of the timeliness requirements of the law. I have nothing else to argue. That's it. Thank you.
Thank you. Okay, now when Victor's ready, up to 3 minutes from the respondent side.
You may proceed.
Hello, as I mentioned previously, my name is Brian Dahl. I am a legislative aide for Supervisor Matt Dorsey, District 6. On behalf of the office of Matt Dorsey, I apologize to Anonymous for failing to acknowledge his request, or sorry, their request within 1 business day. And further, I do apologize for not responding to the public records request within the allotted 10 days time. With that said, the supervisor and therefore any of his immediate staff do not have any records that fall under the request for file number 22110, 2015 order against Herrera. That is all I have to say. And with that, thank you.
Thank you. All right, questions? Any questions?
Yeah, I have a question.
Yeah.
For the petitioner, Anonymous.
Yes.
I believe in your complaint form, you allege violations of 6721B and 6725. It's one or the other.
I don't know if it's one or the other, because 6725 requires the acknowledgement, but then they can extend to 10 days, and they didn't do the acknowledgement. But then even after the 10 days, they didn't provide. They didn't give what state law calls a notice of determination of the existence of public records.
I get that, but the point here is the way the task force has ruled or made determinations is that 6725 has very specific conditions in order to meet the criteria for immediacy, like in the subject line or as a title heading, the words immediate disclosure request shall be placed. There's very specific direction for that. Under 6721B, there isn't any. You just can make a request in any form you want. You can ask the person verbally. You could put it on a Post-it note, send them an email, phone call, what have you. So it's either one or the other. Was this an IDR or was this a standard request?
This was an IDR because the words immediate disclosure request are in the subject.
Okay. Then the 10-day extension under the 6725 then applies. It's not applicable under 6721B. So I just want to make a note of that. Thank you.
No questions from me. Member Stein, no questions, it looks like. Okay. Then we can decide.
If no one else is jumping up here, I will agree with Member Wolf's comments about how to view the violations, and I will make a motion to move this to the consent calendar because they're public records under our jurisdiction, and to recommend finding a violation of 67.25, failure to respond to an IDR. And I might also say 6253C, if we can do that, but.
Is there a separate reason for 6253C? Or is
Well,
it
just it's a timeliness issue under the CPRA. I'm looking at well, the date of this request is actually after the mayor's proclamation, so I can leave it at 67.25.
Yeah, I would say that either way, you could leave it in or not, and let the task force determine it. I just think the 6721 B is not applicable.
Okay.
Since this is going as a consent item, we should provide the violation that you intend to go forward.
I would like to just leave it at 67.25, failure to respond to an IDR.
Yeah, I'll second that.
Okay. Again, one moment. I just want to type this out. The motion is moved by Member Stein, seconded by Member Wolf, to find that the SOTF has jurisdiction, find that the requested records are public, and to refer the matter to the SOTF consent agenda. For violation of 67.25 for failing to respond to a media disclosure request in a timely manner. Are there any other members of the public who wish to make public comment on this item? You can go ahead and raise your hand at this time by pressing *3. Okay, seeing no other public commenters, I can go ahead and move on to the vote.
Let's vote. Yes.
Yes, on this motion, Member Stein.
Aye.
Stein, aye. Member Wolf.
Aye.
Wolf, aye. Chair Schmidt.
Aye.
Schmidt, aye. The motion passes without objection. Next on the agenda is item number 10, announcements, comments, questions, and future agenda items by members of the Complaint Committee. Are there any members? Are there any comments by the members of the Complaint Committee?
I got a quick question, Victor. There's a square on my Zoom that says Stephanie C. And
she is committee clerk observing today and backing me up.
Okay.
Stephanie,
Okay.
would you like to introduce yourself? She is an assistant clerk, and she's just observing us just to see what we do.
Certainly. Thank you for having me today. As Victor stated, I am just here to observe. I apologize for not having my camera on. I don't have the lighting. I wasn't planning on being on camera today.
That's all right.
Just in the background.
I'm glad you came so you could watch how it's done right. Okay.
Absolutely. Thank you so much. Victor is wonderful.
Thanks, Victor.
Is it appropriate to say sausage making, or is it some other kind of making?
Yeah.
So I have a couple things I want to bring up.
Yes.
One has to do with one of the cases that we looked at earlier, and this issue of 67.21D, and how the city attorney functions as a supervisor of records. I'm wondering if we can ask our legal counsel to weigh in on the implications of the city attorney's position, that they cannot fulfill 67.21D because of their obligations to give advice. And I would really love if we could ask them to explain specifically why advice and an order are in conflict. And also for them to maybe review St. Croix, that particular case, and tell us, whether and how they consider it applicable. So I wanted to bring that up because I just, I've, of course, we can all review it on our own too, but I just want to get our legal counsel on that. And then in a totally separate matter, I just want to mention that in the Rules Committee, we talked about the annual report, and it was sort of voted upon that I would shepherd the annual report. And so I wanted to mention that the way that we're hoping to do this, but we're making sure that we have approval, is to have an ad hoc committee just to kind of organize the information that we're collecting. But we plan to do have all of our documents online, publicly available, take public comment on documents that are in progress, but also to have the documents on the agendas of the Rules Committee and of the task force as a full body, if possible, so that there's a regular update in those contexts as well. So I'm hoping to find people who want to volunteer to work on that ad hoc committee, but I'm also looking more generally for either members of the public or task force members who might want to submit statements, brief statements, maybe 500 words or less, either on what they see as practical and policy problems that have faced the task force in 2022, or submissions of case studies of how particular information requests were actually used and potentially had an impact in San Francisco. So two things, just kind of open submissions of case studies or practical and policy problems. And then from members of the task force, if there's anyone here, but I'm going to also mention it in the full task force that might be interested in working on a small ad hoc committee that is by no means a majority of the full task force.
And this is sort of centered on the annual report.
This is centered on the annual report, and I think it'll come onto the full board that a proposal was written for this. It's kind of a, I don't want to say idealistic, but aspirational proposal in the sense that this is everything we could look at. This is all the information we could include, but we have to decide what we can feasibly do and think is smart to do with the resources that we have, and then go forward with that.
Yeah.
So, but one thing we definitely just did discuss and would like to review, if people have them, is case studies and some discussion of the problems that we faced in 2022.
Yeah. Just from my own personal perspective, if you are planning to raise it at the task force itself, I will give it some thought.
Okay.
I may have an interest in the ad hoc committee.
Great.
I don't want to, I'll, Bruce, I don't know if you had anything to say about that matter, but I'm not going to, I don't want to step on you here. I'll give you a chance. But on the supervisor of records issue, I think that I don't buy the position of the city attorney's office. I don't think that it seems like they've tried to figure out a way to just go along, get along, and try to not get in trouble and act like this is enough, but I don't see technically that this is workable. I think that if they're right, I think they need to make it more clear. And so I don't know how, I have tried to sort of like ask before about this role, and I'm not sure if I've been really that impressed with what I've heard. And so I feel like, we can go back to Mark, and it's not that I don't have faith in Mark. I do think it's a hard question, even though, it's in some ways it's a very difficult question. There's a lot of things involved, and yet in some ways it's kind of a small question, but it's not an easy one to answer. I think we should raise it when these cases come up. I don't think that this situation is governed by the St. Croix decision, and even St. Croix is what it is, but I don't think it extends to something like this.
I started to look at it. It does seem to be talking exclusively about attorney-client privilege not being able to be overrode, and I don't know how that intersects with just simply giving advice. But the thing that concerns me, and the reason why I do want to go to counsel, is I feel like I want to give them every chance to make their best argument about how they're analyzing this, so that if we come up with a different way of looking at things, that we've done it with, a full understanding of, how they're squaring their argument. But I am concerned that a lot of their argument seems to be based on things that are not written anywhere, and kind of not even the shadows and the penumbras of the Sunshine Ordinance, but just, what's missing there. And there isn't much discussion about what is in the Sunshine Ordinance, which, seem to give us oversight over elected officials choosing not to do their duties under the Sunshine Ordinance.
I want to parse something here, because my view on this, and I haven't seen this bear out yet, and it's a weird animal in the law, but my view is that we're supposed to have our own advisor who just happens to work down the hall at the city attorney's office from the people who represent the city. But my view is that they don't necessarily have to have the same answer. Mm-hmm. And I want to just make sure that if you want to ask the question of somebody who has the name city attorney, are you talking about our guy, and I think it's just our one guy right now, or do you want to ask someone who's in the sort of the main office to justify what their position is on it?
Honestly,
because those could be two different answers conceivably, in my opinion.
I hear you, and honestly, I think I would like both. I think they've laid out their perspective. I think it's a very it's an incomplete perspective in terms of making the strongest argument they can. But if they want to deal with really parsing St. Croix and considering things that are written in the Sunshine Ordinance and why their understanding controverts those things, I would like to hear that. But I also would like to know from our person, what they think. And I'm hoping that maybe that is a slightly different perspective.
Yeah. And, I think that could, even though I think that Mark should feel the freedom to differ, I don't know if he does. Mm-hmm. And that's just something I haven't seen yet. I haven't seen the answer to that yet.
Can I chime in here?
But that's something that I'm very, I'm trying to kind of pull that out of him, but he's resisting me. I don't know if you've noticed that.
Yeah, I saw one of your email exchanges where that resistance.
Yeah. And we'll see.
So I just want to chime in here that this is, not a novel item of discussion that task forces over the years have, been struggling with this for a long time. And we have asked this question of our legal, I want to say our legal counsel, because no matter which legal counsel is assigned, they get us the same answer. So it doesn't really matter whether it's this one or the previous one or the one previous to that. We keep getting the same answer. That they basically say that there's an ethical firewall, which means that they won't discuss matters with other staff, in the city attorney's office. That is the extent of it. If the city attorney holds some opinion about something, then they're just going to iterate that. That's not their role as legal advisor. It's really more about are we reading the law correctly or not, kind of thing, versus having an opinion that might be different than the city attorney. That has been our experience. Whether that's correct or not is a different story. Okay, and we can argue till the cows come home, of whether that's the case or not. But I will say that there have been instances where we have made some challenge to that, and that it's never been resolved. And just by rehashing this today with St. Croix versus Grossman, the thing is that was never appealed or taken to a higher court, because Mr. Grossman was, very elderly. He was not of good health, and he had died soon after. And I think the fact that it just stopped right there, and we didn't have necessarily the ability to chime in on it. We didn't do like a friend of the court, an amicus brief on it or anything like that. Because Mr. Grossman's arguments were pretty solid, but for some reason there was a hole that got.
But that also, just from having perused it very briefly, it seemed like it had to do with whether documents could be public that were part of an attorney-client relationship, and here we're talking about something kind of different.
Exactly. And so, I think that the question here, though, is what is the role of the city attorney? Can they serve in two different roles? The Ethics Commission does. They serve for campaign finance and all that stuff, and then they serve with the official misconduct stuff. So they can, they've got jurisdiction in two different sets of laws. And I think that that's very possible. There was something else I was going to say, I can't remember, but I just think that that's kind of important to get clear, because I think they have a role to play here, and whether, this is about general compliance of government. This is not about their client, right? That's the way I kind of see it. It's not about their client. This is about, general. Let's put it this way. Is publishing the Good Government Guide, is that going against attorney-client privilege? Because they're providing directives to their clients? I mean, it somewhat flies in that environment there. So I think it's, because nobody challenges it, it just rides the way it rides. And I think it's worth challenging. And if we think that it's worthwhile to have a court decide what it is and whether the ordinance actually has some jurisdiction to supersede that, then let's find that out. It's really just a matter of, does does the judicial system see it? How do they see it? You know, and let's find out once and for all, because then the ordinance will have to be adjusted because those sections don't apply, and that's misleading to the public if they still are in, you know, in writing on the books, but there's
Or it's a willful failure to
or
discharge duties imposed by the Sunshine Ordinance.
well, there's that too. So, you know, I don't know. It's a to me it's very questionable, and I think some questions need to be answered by some authority that is not them and is not us, and it's not city government necessarily, because the Sunshine Ordinance is to be applicable. You can't, you know. That's why we're here, right?
Mm-hmm. So do we know any good pro bono lawyers?
Yeah, there's one sitting right there. He's got a smile on his face, wearing glasses.
Oh,
And actually holds the role of lawyer on this task force.
Yeah. Well, you know, I think I don't to the initial inquiry. I don't know if we're going to get much more from the main city attorney's office about explicating their argument than what's already in the file here. I have seen that I looked at two different versions on different dates, and I saw that they had scaled back one or two of the arguments. And I understand maybe that I can see why. And it may have been because we started to look at this and it came up here. The timing, I'm not saying I know that, I'm just speculating. So that's one thing. If you want to go to them to explicate, fine. But I don't know if you're going to get anything more than what they choose to submit when it goes to the task force. If you want to go to Mark, let's say Mark, or if you want us to go to Mark, I know, you know, I've tried to ask him, and I've tried to present, you know, it in the way, and I could do it again. We could do it jointly if you want. Maybe we could do it jointly as a committee. Please answer this question, and we'd say it's in connection with that case.
Yeah.
And see what Mark says. If you want to do it.
Yeah, I'm happy to draft an email and forward it to you, and you can add anything and forward it on if you want.
Okay, let's do that.
All right.
Yeah, I would make it applicable to a case, because then it, you know, and you have some, you know, example.
Mm-hmm.
Let's connect it into 20104, because that's the one where their briefing is sort of the most evolved on this supervisor issue.
Right.
Okay.
I just wanted to just get down to what you would like me to do. So you would like to request advice from our DCA regarding this issue in relation to file number 20104?
Oh, we'll do that directly.
Okay.
So you don't have
I won't do anything. I will leave it to you to act on your own.
Okay.
Yeah, yes, Victor. I think that's the way to do this one. We'll just say, how about we say it's from the committee? Is that all right with y'all?
Yeah, that's fine.
Okay. Okay.
Yeah, we're seeking advice.
And I don't. Okay. Anything else on our et cetera number at the end of the agenda?
Okay. We do have one member of the public who would like to provide comment.
I'll allow it. I know that there's some issue about whether it's supposed to be allowed, but
well, since we did provide comments and
yeah, that's fine.
Anonymous number 3, would you like to start your comment?
Yes, this is anonymous number 3. I'm pretty concerned about what the committee just did right now. you're discussing something related to a public hearing that you already did under item 5. You already made a motion, approved the referral of my case to the full task force, and you did not condition it on a DCA advice. And the reason I am so worried about what you might be doing here, I'm not completely certain, is that one, it's a different agenda item on the schedule, and two, the last time, I'm not sure if you're conditioning the hearing of the case at the full task force based on your own legal counsel advice, but when you've done this in the past, they just wait months to give you that advice, which means you're giving the city attorney's office the ability to control when I get heard, and this is a 2-year-old case already. So I please ask you, yes, if you want to get advice, that's great, but I don't think you're reopening that case and making a conditioned referral on that case. And if you are, then I'd ask you to also, give me and give the other party a chance to speak on that matter itself. Thank you very much.
Thank you. And yeah, I've learned that I'm not going to wait around for our city attorney on anything. It's maybe they'll get faster, but so far I wouldn't myself. But I have the advantage that I'm an attorney. I'm a practicing lawyer, so I have an advantage. Unfortunately, there are members who don't, and they would rely on having that legal advice more than I would. But I don't think there's any reason why your case should wait until we get, what could possibly be a more enlightening advice, or what we could get is just something that's more useless. We don't know. I don't think we'd get an answer. And so, no, it's not going to be conditioned.
Yeah, there was no discussion of making it conditioned. It's just that this is I think we were talking about using the case as like a little bit of a hook to concretize the feedback that we might get, but we are not saying that hearing the case depends on getting the attorney's position, the legal advisor's position.
Yeah, Anonymous, you could speak if you have something else.
Okay, it sounds like you are not making a change to an item already on the agenda. This is just something you're separately doing, but it's not going to have any effect on my file itself. So.
No, it's not. And I'm glad you brought it up because it's good to make that clear. Okay, thank you. Victor, next item.
Okay, are there any other members of the public for public comment? We do still have Peter Warfield on the line, but he is not raising his hand. So we can close public comment on this item. And next on the agenda is adjournment.
Move to adjourn.
Second.
Okay, the meeting is adjourned.
All right. Take care, everyone.
All right.
Take care.
File.
Thank you.